All right. Good morning, everyone. Court will continue with the April 19, 2022 docket. And I'm trying to get Mr. Willie McKellen and Mr. Adler on board. All right. Good morning, Mr. Adler and Mr. McKellen.
Morning, Your Honor.
Mr. McKellen is still on mute. There you go.
Morning, Your Honor. How are you doing?
Good morning. Pretty good. Good to see you guys. I believe we're in a status conference on CL 214139D, Jose Guerra versus State Farm Lloyds. Is that the case?
Yes, Your Honor.
All right. And I have it here for today for status conference. Anything to report? Anything to report, gentlemen?
I don't think so. We're in the appraisal process unless Mr. Adler knows something different. I think they're still, hashing it out.
Yes, Your Honor. So this proceeding is an application for a court-appointed umpire. There was a hearing on the application in February.
Okay.
And a colleague of mine handled it, but the court notes reflect that the court instructed the parties, talk amongst yourselves, try and reach an agreement on an umpire. If you can't agree, file a motion for a status conference. That's what we did. I conferred with Mr. McGowan. We couldn't reach an agreement. So that's why I filed the motion for a status conference. We have, State Farm has 3 recommendations for qualified umpire candidates.
All right.
Our policy is pretty specific about who qualifies. They have to be an engineer, architect, adjuster, public adjuster, or contractor. If they're a contractor, they have to have experience and training in the estimating, repair, and construction of the type of property damage in dispute. We suggested 3 people. I think Mr. McAllen hasn't filed any recommendations, so I believe the court can just pick one of the people that we recommended.
All right, Mr. McAllen.
Your Honor, and I usually file something. I don't know what happened there. I'll put in a name of people that are qualified. If I could have, what's today? Tuesday.
Today is Tuesday, right?
2 days, so by Thursday.
Right. Go ahead and do it by Thursday because maybe I can pick someone by Friday.
Thank you, Your Honor. That'll be perfect.
All
I think
right.
that's all we have.
Okay. Yeah, we need an order and leave it blank, and I'll put the name in there. Okay. Unless it's already an order on file, but I'll go ahead and pick somebody on Friday.
Thank you, Your Honor. That's all the business I have before this honorable court, Your Honor.
You both may be excused. Have a great day. Thank you.
Thank you.
Thank you very much.
Thank you. Bye-bye. Number five. Miss Perez.
Yes, hi, Judge. Good morning. How are you?
Yes, ma'am. Fine. Thank you very much. You're here on F1105-22-4, Marcelina Torres versus Santiago Castro, right?
Yes, Judge, I am. And she is present here on the Zoom under Marcelina Castro.
Okay.
And we're just set for temporary orders, Judge. The respondent is in jail. He has been served. And really all we needed for the temporary orders was to give her exclusive use of the residence temporarily because he is in jail and we do have a protective order pending as well.
There's a protective order pending. Okay. All right. Okay. And what else did you need? The exclusive use of the home and what else?
That's it. I don't even believe she has a vehicle, Judge. So I think it's just the home that we were asking for.
All right. And of course, Mr. Santiago Castro, he did get served and everything, right?
Yes, Judge. He did get served by the sheriff's office. And then we also have a green card as well where we sent it to.
All right. And he's in custody right now. All right. Court will take judicial notice of the entire filing F1105-22-4. In the case of Marcelina Torres versus Santiago Castro, court will hereby grant the petitioner's temporary orders.
Thank you, Judge. We'll submit an order.
All right. You may be excused. Thank you very much. Have a great day.
Yes, thank you. Have a great day.
Bye-bye. Bye-bye.
Number 9. It's a default.
Number 9. And who do we have here for?
Miss Katie Klein is logging on.
Okay. Or somebody in for her.
Stephanie.
All right, Ms. Klein, can you hear me? It's another one?
Turn off this.
Okay. Can you all hear me? There you go, Ms. Klein. How you doing?
She's muted.
You need to unmute.
Good morning, Judge.
Good morning, ma'am. How you doing? All right.
I'm doing great, sir.
Great. Okay. And your client is,
Stephanie Bowl.
and she's there on the screen?
Yes. You want to stay here with her? Yeah, she's here.
All right. She needs to unmute.
I was actually going to have her speak loudly so we get feedback.
Yeah,
Sorry?
I'm gonna mute her because then we're gonna have a really bad feedback.
Okay. I
We're in the
understand.
same-
So I just told her to speak up so that you'll pick her up from my speaker.
Yes, that'll work. Yes, that'll work. By the way, we're here on F5031-21-4 in the matter of the marriage of Stephanie Bowell and Brett Martin.
Yes, correct, Your Honor. This is a
was it?
default divorce,
Uh-huh.
and we have filed our motion with our proof of service. He was served on December 28, 2021. And we also provided the certificate of last known address and the non-military affidavit, which I'd ask the court to take judicial notice of.
All right. Court will take judicial notice of the entire file.
Thank you, Your Honor. And if you would swear my client, please.
All right, Ms. Ball. Good morning, ma'am. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You may put your hand down. And Ms. Dell, you may proceed.
Thank you.
And Ms. Ball, just answer a little bit louder so the court reporter can hear you. Okay, ma'am? All right. Go ahead, Ms. Klein.
Ms. Bowell, you're the petitioner in this lawsuit against Brett Thomas Martin. Is that correct?
Yes,
And you're the mother of two children, and your children are Georgia, who has a date of birth of 10/23/2018, and Indiana Martin, whose birth date is March 13, 2021, correct?
yes,
And your husband left the home, and he has had some problems with use of drugs that has not benefited him, correct?
yes,
And so you elected to go ahead and get a divorce because he's not living with you and he's not seeing your children, correct?
yes,
And you're going to ask that you be appointed the sole managing conservator, correct?
yes,
And you told him about this hearing in addition to him getting the notice of hearing, correct?
yes,
And he told you he did not want to log on, correct?
yes,
And his separate property house in which he's residing is the one that we put in his certificate of last known address, 320 North 7th Street, McAllen, Texas, correct?
yes,
And you understand that he has not had water in that home for several months, correct?
yes,
And are you asking the court to have supervised only access at this time on the first, third, and fifth weekends from Saturday, 4 to 6 p.m. and Sunday, 3 to 5 p.m.?
yes,
And you are very close to his parents, Dr. Eric and Christy Martin, correct?
yes,
And you are asking that Dr. Eric or Christy Martin or your mother, Nora Alicia Bowl, supervise the possession of the children, correct?
yes,
And you feel comfortable with any of them?
yes,
And you have a Nissan Rogue vehicle that is being gifted to you by Dr. Martin. It has a title, hasn't been transferred, but you're asking that as between you and your husband, that the Nissan Rogue be awarded to you, correct?
yes,
And you're asking that his Dodge Avalanche be awarded to him, correct?
yes,
And because, and he also has a number of unsecured weapons in his home, is that correct?
yes,
He has handguns and AR-15 and shotguns, correct?
yes,
And you are asking that he not be permitted to take your children around guns, correct?
yes,
And they are babies, right? They're a 3-year-old and a 1-year-old.
yes.
All
Yeah.
right. And you have jewelry that's in a closet at his home, and you are willing to have the safe, it's in a safe, and you're willing to have it cut open at your expense and have his father supervise the removal of your jewelry from the safe, correct?
Yes.
Your husband tells you he can't open it or doesn't know how, correct?
Correct. Yes.
And you're asking that he have telephonic access with your children twice a week on Monday and Wednesday from 5 to 5:30, correct?
Yes.
And do you, you're asking the court to grant you a change of name to Stephanie Bowl Martin, is that correct?
Yes.
And you're asking the court to grant this divorce on the grounds of insupportability, correct?
Yes.
And were both of you residents of the county and the state of Texas for 6 months at the time that you filed your petition for divorce?
Yes.
Do you believe that this property settlement agreement, which includes each of you keeping what's in your own possession, like furniture and personal belongings, do you believe that's a just and right division of your property?
Yes.
Am I correct that there are no stocks and bonds, brokerage accounts, or anything like that, other than just your personal funds?
Correct. Yes.
And do you believe that this order with regard to your children, that you be appointed sole managing conservator, do you believe that that's in the best interest of your children?
Yes.
The last tax return that your husband prepared was his 2020 tax return. And the child support calculation, his net resources were $11,195.71. Is that correct?
Yes.
And the child support for 2 children based on those net resources is $2,798.93, correct?
Yes. Correct.
And you're asking the court to award that child support based on his last tax return, and also that he be obligated to provide medical and dental insurance for the children, correct?
Yes. Correct.
Do you know whether or not at his current employment he has medical and dental insurance available?
No, I do not.
Do not know. So you're asking the court to award that if he has insurance, he provided, and if not, that he reimburse you for whatever you provide for them, correct?
Yes.
At this time, are the children on Medicaid?
Yes.
But he recently started a new job, and you don't know all the details of that,
I do
correct?
not, no.
Okay. And so do you believe that this fairly and adequately disposes of all the issues before the court, including your property, the best interest of your children, and your change of name, correct?
Yes.
And are you asking the court to sign a decree of divorce in accordance with what you've just testified to?
Yes, I am.
That's all I have, Your Honor.
All right, thank you, ma'am. Court will take judicial notice of the entire file in cause number F5031-21-4 in the matter of the marriage of Stephanie Bowell and Brett Martin. Court will hereby dissolve the marriage of petitioner respondent. Court will hereby grant petitioner all relief requests to hearing in open court. Court will await a final decree for divorce for signature. Anything else?
That's all. I'm sorry. Right. And Your Honor, we're going to have no geographic restriction in the decree, and also asking that she have all the exclusive powers with regard to the children. One more question. Ms. Bowl, you know that we've not asked for back child support, correct?
Correct.
Because there was a period of time he was unemployed, correct?
Correct.
Are you waiving that right? You don't want to seek back support from him at this time?
That's fine. Correct. Yes.
So we'll waive retro, Your Honor.
All right, very well. Yeah, go ahead and file the decree and we'll sign it. Okay, ma'am?
Thank you, Your Honor. I really appreciate all your help. Thank you so much.
Sure, you're excused. Have a great day. Bye-bye.
Have a great day, Judge.
Bye-bye.
Number 1, Mr. Velasquez.
Number 1. All right. All right, welcome back, Mr. Velasquez.
Hello, Judge.
Yes, sir. I believe how many cases today? Just one?
Just one today, Your Honor. 10. I had one at 10 and one at 11.
When you appear in court, we're used to multiples, and this one business is kind of slow for us. But anyway, we'll go with CL 1835-20D Portfolio Recovery Associates LLC versus Eduardo Tafoya. Court will note that Mr. Tafoya is not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed.
Thank you, Your Honor. This morning, Judge, we are seeking damages in the amount of $1,366.03, cost of court, and post-judgment interest at the statutory rate. As the court has taken judicial notice of any and all documents previously filed with the court, I would move the court at this time to admit any and all exhibits previously filed with the court in support of this morning's prove-up. In brief, plaintiff filed suit against defendant on or about July 25th of 2018. Defendant was served with a copy of plaintiff's petition and citation on or about August 4th of 2018. Despite being duly served, defendant has failed to file an answer or any other pleading constituting an answer, and as such, default judgment is appropriate. I would move the court at this time to grant judgment in the amount of $1,366.03 and all other relief requested.
All right, court will hereby admit all exhibits offered. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. Anything else, Mr. Velasquez?
Nothing further, Your Honor. That's all I have for today. I was going to take a whole bunch of cases on Thursday. I think you got a full docket on Thursday.
Oh, okay.
Out of your
Then,
court.
okay.
Yeah,
All right.
but unfortunately, I had a time conflict and I was not able to accept those cases. But it's always an honor, Judge, to appear in your court. And I hope you have a wonderful day.
You too. Likewise. Have a great day. Okay, sir. Thank you.
You too, Judge. Take care.
Bye-bye.
Bye-bye.
Number 10.
Number 10. All right, number 10, Mr. Alamia and Mr. Jesse Contreras. I don't know if it's on the screen. There he is. Mr. Contreras needs to unmute. Anybody in his office?
Your Honor,
Needs-
good morning,
Yes.
Judge.
All right, there we go. There we go. All right, Mr. Contreras and Mr. Lamia, good morning. We're here on F5571-17-4 in the matter of the marriage of Ricky Martinez and Elsie Velasquez. Yes, gentlemen, what do we have?
Your Honor, we filed a motion to waive mediation. Mr. Contreras and I had an informal get together with the clients. We could not resolve any of the issues. And we're asking the court to waive the formal mediation and set it for a trial.
Oh, okay. You understand that if we do set it for trial, this trial may not happen till, I'm not too sure, even next year, because we're so backlogged, we're so behind and so forth. Unless you want a bench trial.
A bench trial, that's what we're requesting, Judge.
Okay, a bench trial.
Yeah.
All right, all right. It still may not be down the pipe. How long do you think it might take?
Sometime next year, because we have.
It'll be like next year. Yeah. Yeah, there's so much backlog, but I mean, see, I guess you're gonna have to file your DCC or something, and we'll try to
Your Honor,
give you something as quick as possible. It may not even be this year.
Judge, I did file a motion for DCC, so we'll just wait for you.
Okay, you filed it already.
Yeah, I did file a motion for
Yeah,
DCC.
just that they know it's next year.
Okay, so it may be next year, guys, but
No, no
I'll try to
problem.
get you something quick. What were the main issues that you all couldn't agree on? Was
The
it
main-
family, children?
The main issue is the community property, Judge. One piece of property that we, our position is it was community. Mr. Contreras says it was separate, so that's an issue, basic issue.
Okay, all right, it'll be, okay. All right, so this is DCC on file. Let me work on it and I'll get back with you folks, okay?
Thank
So
you,
the
Judge.
court-
Appreciate it.
the court is granting my motion to waive the mediation, Judge.
It'll be reluctantly waived.
Okay, Judge, and
We'll
we'll set
waive it.
up.
Good morning.
We'll waive it, but then I'll get a DCC going. All right, thank you, folks. You may be excused. Thank you.
Thank you, Judge.
Thank you, bye-bye.
Number 7.
Number 7. All right, number 7, Mr. Fabian
Good morning.
Guerrero.
How you been?
Yes, sir, Mr. Guerrero. Good to hear from you. Good to see you again.
Likewise, Your Honor.
We're
I have-
here on a final divorce, right, sir?
Yes, Judith Rodriguez is the petitioner in this case. She's
Okay.
present. Mr. Panquilo Rodriguez Jr. was served by mail, and Miss Judith was sharing with me that he was aware of the Zoom. I'm not sure if he showed up at the courthouse.
Okay.
This is a
No, I don't see him in the waiting room here on the screen, and
That's right.
also there's no.
That's freaking shut up with the court.
Yeah, he did not show up at the courthouse either.
That's right.
Oh, Rick.
Does anybody?
Yes, sir,
want-
Judge, for the record,
Mr.
yes, for the record, the respondent, Panfilo Rodriguez, has not shown up here to the office.
All right. Thank you very much, Rick. Thank you very much. Okay, so then we'll proceed for the final divorce here, Mr. Guerrero. So court will take judicial notice of the entire filing, cause number F1708-19-4, in the matter of the marriage of Judith Rodriguez and Panfilo Rodriguez Jr. Ms. Rodriguez, you need to unmute.
Okay.
All right, good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down and listen carefully to the questions. Mr. Guerrero, you may proceed, sir.
Okay, Judge, I will just say before I begin, Miss Judith Rodriguez has children with Panfilo Rodriguez, and that those children are being dealt with a cause number with child support of F8408-10-4. And I want to address this with the court before I continue. I did appear for Miss Judith Rodriguez in that case number and that cause number. Did speak to Polo from child support. He indicated to me that he had income information on Panfilo, and he rescheduled that hearing for in-person June 16th of this year to deal with child support. And I asked him if they were going to intervene, and he basically told me the following, and it's going to be up to the court how the court wants to handle this, that I could go forward with my divorce and reference this cause number in the decree, and they will deal with assessing the appropriate amount of child support. The only thing I would deal with is visitation and whatever other matters I had before the court. Now, I want to know whether the court would allow me to proceed in that manner so I can finalize this divorce.
Oh, okay. So
then you won't be able to sign the decree till after June 16th? Or
well, I guess I won't be able to sign the decree until the numbers are incorporated in
Right.
the decree.
Because I do have I don't have this. Let me explain why this case is a 2019 case and it's still on the court, and so court can get an understanding of what we're dealing with here. Miss, to her credit, tried to make it work with her husband. They made an effort to reconcile during the interim from when I filed this petition till most recently. They were unable to make their marriage work. So then I got this case back on track, so to speak. So I have not done some discovery that I would feel comfortable doing if I had to go ahead and pursue an appropriate amount of child support.
Yeah.
We have some general numbers, but I do not have the proofs to support them.
Okay.
So how would the court want me to handle this?
Yes, out of an abundance of caution, I think we better just reset the matter, Mr. Guerrero. And as soon as you get those numbers and you're ready to go, just let the court know. We'll get you a quick hearing.
Can I at least ask the court for temporary orders appointing both parties as JMCs with Judith Rodriguez as the primary for the children subject to this proceeding, and awarding her temporary possession of the property and the mobile home located at 5012 Plano Lane, Mason, Texas, and awarding her exclusive possession of that for the interim judge. And so at least I can have some form of stability while we're waiting for this case to finalize. That be appropriate for the court? Could I prepare an order?
Yes, so granted and ordered. Just submit an order, okay, sir?
Thank you so much, Judge. I appreciate it.
All right, so you're excused. Have a great day, and you stay safe.
Good.
All right, thank you. Bye-bye.
protect them.
Okay, so ready to go?
Yes.
All right, who's going to be the attorney here?
Ms. de la Tejera.
Ms. De La Tejera.
Yes.
Who's here?
There's somebody with DA.
Can you hear me, Your Honor?
Yes, I can. Good morning.
Oh, great. Hi, this is Alessandra de la Tejera.
There's somebody here on the screen with a D, capital D, capital A. I do not know who it is. They need to unmute.
Hi, I don't know. I'm just waiting.
Yes, sir. What's your name?
Diego Alarcón.
Oh, Diego Alarcón. That's the one we called earlier, right?
Okay, yeah. So nothing's gonna happen.
Not why? Which case is this? This is the one where you
Let me see.
had on the motion when you trial?
Okay, yeah, he needs to wait. We're not ready.
Okay, we're not ready yet, Mr. Alarcón. We'll get there in a little while, okay?
Yes, please.
All right, Ms. De La Tejera.
Yes, Your Honor. The respondent was served on the 5th, and so I expect today's going to be a default.
Okay, we're here on P0062-22-4. Is it Alicia Marie Mejia versus Eric Alvarado?
Yes, that's right.
All right, and this is the gentleman you said that was served on the 5th?
That is right. I'm so
Right.
sorry, on the 4th, and it was returned on the 5th.
Okay, served on the 4th and then returned on the 5th. And court will note that Eric Alvarado is not in the waiting room. Therefore, court will take judicial notice of the entire file. And let me go ahead and swear in Ms. Mejia. You need to unmute, Ms. Mejia.
Yeah.
All right, good morning, ma'am. Please raise your right hand. You
Good
swear
morning.
the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. All right, Ms. De La Tejera, you may proceed.
Ms. Mejia, you had a dating relationship with Mr. Alvarado, is that right?
Yes.
And you're no longer together,
No.
but you do have kids with him.
Yes.
How old are the kids you share with him?
They are 6 and 9.
And is it correct that you first dated from about 2011 to 2013?
Yes.
Then you dated again from about 2014 through 2017?
Yes.
And then did you briefly get back together for about 6 months in 2020?
Yes.
Aside from those 6 months in 2020, have you been in a relationship with him since 2017?
No.
When you've been broken up from Mr. Alvarado, has he stalked you?
Yes.
Would he follow you home?
Yes.
Would he drive by your home or your friends' homes?
Yes.
Would he ever knock on the doors of people you knew and ask for you?
Yes.
Did he ever represent to the police that he lived in your apartment when he didn't?
Yes.
And when you were broken up, how often would he stalk you?
It happened pretty often.
Did he send you
Every-
messages with pictures of cars that you were at or outside of the building you were at?
Sometimes.
Was Mr. Alvarado ever physically abusive with you?
Yes.
Did this abuse include hitting you, which refers to slapping, kicking, or punching?
Yes.
Did he ever strangle you?
Yes.
Do you remember an incident of physical abuse that happened a few days after you gave birth?
Yes.
Did Mr. Alvarado hit you at that point?
Yes.
Is it correct that when you broke up with Mr. Alvarado in 2017, he elbowed you in the face repeatedly?
Yes.
And then he tried to take your phone so you couldn't call the police?
Yes.
Then he did take the battery out of your car, is that right?
Yes.
At that point, you were able to call the police?
Yes.
Mr. Alvarado moved to Michigan sometime between October 2020 and May of 2021, is that right?
Yes.
And during the time that he was in Michigan, he did not stalk you.
No.
He did start stalking you when he got back, is that right?
Yes.
And you found out that he was back because he showed up at your apartment at about 1 a.m?
Yes.
And after you refused to let him in, he called the police?
Yes.
And this is when he told the police that he lived at your apartment?
Yes.
The police officers told you that your address was actually listed on his ID, is that right?
Yes.
Now, to be clear, had he ever lived at that address?
No.
Do you know why he had your address listed on his ID?
No.
But you were able to get the police and him to leave after you showed them your lease, is that right?
Yes.
The last time that Mr. Alvarado was physically abusive with you was this past December, is that right?
Yes.
You let him come over on Christmas to watch your kids open presents?
Yes.
He started to insult you, and then when he refused to leave and you tried to get him to leave, he threw you against the wall?
Yes.
And you did call the police?
Yes.
But he was already gone when they arrived?
Yes.
Then this past February, on February 11th, he broke your apartment window?
Yes.
Okay, and that's not the first time he's broken one of your things, is it?
No.
Am I right that the items he's broken include a TV, a door, car windows, apartment windows, mirrors, and phones?
Yes.
Does Mr. Alvarado have explicit pictures of you?
Yes.
Has Mr. Alvarado ever sent you an explicit picture of you that you did not know he took?
Yes.
In that picture, were you unconscious?
Yes.
And he sent this picture to you when you were broken up, is that right?
Yes.
Now, you're asking the court for a protective order because you feel you need one for your safety, is that right?
Yes.
So you're asking the court to pay your attorneys, you're asking the court to order him to pay your attorney's fees, excuse me.
Yes.
You're asking that your address remain confidential.
Yes.
You want him to stop stalking you.
Yes.
You expect to co-parent with him for at least another decade, is that right?
Yes.
And you'd like to be able to co-parent without harassment.
Yes.
So you feel that you need a protective order in order to co-parent safely and ensure your safety.
Yes.
Pass the witness, Your Honor.
All right. Court will hereby take judicial notice of the entire file. Court will hereby grant the petitioner all relief requested hearing in open court, including a protective order. And anything else, Ms. Del Tejeda?
We're asking for a lifetime protective order, Your Honor, due to the stalking.
So ordered. Just submit the order for signature, okay, ma'am?
I will do that. Thank you, Your Honor.
All right, Ms. Mejia, thank you very much for your testimony and good luck out there, okay, ma'am?
Thank you.
All right, stay safe. Have a great day now. You're excused. Bye-bye.
Number 8.
Number 8?
Mhm.
Number 8, number 8. Mr. Cantu. Okay.
Morning,
Yes, sir.
Judge.
Good morning, Mr. Cantu. How you doing?
Doing well, thank you, Your Honor. How y'all doing?
Oh, fine, thank you. We're set for a final divorce here today?
Yes, sir.
Okay, and respondent Juan Pablo Rodriguez did not make an answer, did not file an answer, I'm sorry?
That's correct, Your Honor. The respondent, we properly served him, and no answer was filed.
All right, so therefore it'll be a default divorce hearing. And that's your client right there next to you?
That's correct, Your Honor.
Okay, and we're well, first of all, court will take judicial notice of the entire file in F3507-20-4 in the matter of the marriage of Diana Anselma Rodriguez and Juan Pablo Rodriguez. All right, you may proceed, Mr. Cantu, and your first witness is going to be Ms. Rodriguez, right?
That's correct, Your Honor.
All right, please. Good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may put your hand down, and Mr. Cantu, you may proceed, sir.
All right, thank you. Ms. Rodriguez, can you state your full name for us?
Diana Anselma Rodriguez.
Okay, and you're the petitioner in this case. You have filed the petition for divorce?
Correct.
Okay. And currently you're married to
Juan Pablo Rodriguez.
Juan Pablo Rodriguez, and he is the respondent in this case?
Correct.
Okay. And we properly served him through the requirements of the law?
Correct.
Okay. And you're asking for a divorce from him?
Correct.
And do you remember when you were married to him?
It was in October 2008.
Okay. And do you remember what day you and him stopped living together? What day y'all were separated?
It was between March, April of 2015.
Okay. And have you been living in Texas for the last 6 months?
Yes.
Okay. And have you been living in this county of Hidalgo for at least the last 90 days?
Yes.
Okay. And did you and Mr. Juan Pablo Rodriguez have any children together?
No.
No. And y'all are not expecting any children?
No.
Okay. And as far as any property that y'all bought after marriage, which is considered community property, do y'all have any property that y'all own together?
No.
No. Did you purchase a vehicle after your marriage?
Correct.
And you're asking the court to order that vehicle be ordered as your separate property?
Correct.
And what type of vehicle is that?
It's a 95 Dodge Dakota.
Okay. And we've included that on the drafted divorce decree.
Correct.
Okay. And so any property that is in your possession, you're the court go ahead and order that as your separate property?
Correct,
And any property that Mr. Rodriguez may have in his possession to go ahead and order that as his separate property?
correct,
And any debts that you may have incurred, and any liabilities that you may have incurred, will be ordered as your debts and your liabilities?
correct,
And any debts and liabilities that Mr. Rodriguez may have incurred to be ordered as his?
correct.
Okay. Lastly, you'd like for a name change to be done.
Correct.
Currently, what is your legal name?
Diana Anselma Rodriguez.
Okay. And what would you like your name to be changed to?
Diana Anselma Lopez.
And lastly, again, you're asking the court to grant this divorce.
Yes.
Yes. Okay. Pass the witness, Your Honor.
All right, thank you very much. Court will hereby take judicial notice of the entire file. Court will hereby dissolve the marriage of petitioner respondent. Court will grant petition or relief request to hearing open court. Court will await a decree for signature. Anything else, Mr. Cantu?
Your Honor, I had e-filed a proposed divorce decree. There was some mistakes on it. And so I just e-filed another one maybe 30 minutes ago.
Okay, just make sure it's an amended decree, okay? Amended final decree of divorce.
I'll put that on the title?
Yes, amended final decree. Okay?
Okay, will do, Your Honor. Yes, sir. Thank you, Judge. That's all we have. May we be excused?
Yes, sir. You and your client are big excuse. Have a great day. Thank you. Bye-bye.
Number 2.
Okay, number 2. All right, let's see here. We have, let me see here. Let me see. Number 2, Mr. Sonny Palacios. There he is. Good morning, sir. Still morning. And Mr. Garza, Sergio Garza.
Good morning, Judge.
Yes, sir. Good morning. And I believe we're here on CL 2017-79D, GIY International Corporation versus Diego Alarcon. And it is a motion for new trial. Is that your motion, Mr. Palacios?
Judge, that is Mr. Garza's motion.
Oh, Mr. Garza's motion. I'm sorry.
That is correct, Judge.
All right, Mr. Garza, you may proceed, sir.
Well, Judge, defendant Diego Alarcon, it's his motion for new trial and to set aside default judgment. As the title of the motion suggests, plaintiff obtained a default judgment against my client, Diego Alarcon, who was in their motion for, in the underlying motion for default judgment, plaintiff alleged that Mr. Alarcon was served by publication. And my client, Mr. Alarcon, did not have actual notice of the lawsuit until after the default judgment was signed. Attempted service was made according to the underlying records prior to the default judgment. Service was attempted at Mr. Alarcon's former place of business or employment where he was employed. When attempts to serve him there were made, he was no longer employed there. That's why he didn't receive notice of the or he wasn't served with process then. So plaintiff then made him filed a motion for a default or for substitute service, and then plaintiff claimed that service was made through publication. Mr. Alarcon did not receive any actual notice, like I said before, until after a default judgment was signed. When somebody told him, a friend of his told him there it's a car lot, a used car lot. Somebody called him and told him, hey, there's a default judgment against you. That's when he first realized that a lawsuit had been filed against him. And then he made contact with myself and co-counsel, Mr. Ricardo Ramirez, and we filed this motion for new trial as soon as we could.
Okay, and the default judgment was granted when? Do you have a date for that?
Default judgment was granted February 24th, 2022.
February 24th of this year, 2022.
This year, yes.
Okay.
That's great.
All right. Okay, Mr. Palacios.
So, Judge, we do have, of course, this is outside the date. It was done on February 24th. This should have been handled by March, by the end of March. However, going even more into that, what the affidavit doesn't state is who called Mr.
Alarcon.
Alarcon from Top Choice to tell him about the judgment. Where did he call him? From what number did they call? When did they call? How? None of those specifics are stated, so there's no way to test the veracity of those statements or to see if the affidavit is in fact true. I would like a chance before the court even considers agreeing to this motion for new trial to test the veracity of those statements, because that's the truth of the matter, the conscious indifference. Mr. Alarcon could be filing an affidavit with the court stating that, oh, someone called me to inform me that there was a default of judgment, but they don't afford us the opportunity to test the veracity of the statement. I would like to know who called, from what number did they call, when did they call, what was the substance of the conversation, because other than that, then it's just hearsay, which is excluded.
Okay, and I think yes, sir, Mr. Garza.
Yes, and I just like to point out that the motion was timely filed, and because the service in this case was by publication, it's not the regular 30-day deadline that applies. It's actually 2 years. But regardless of which deadline we apply, the motion was filed within 30 days from the default, right? And also, I would like to point out that the details that Mr. Palacios is inquiring about are not actually needed to rule on the motion, because the affidavit is there and it meets the craddock factors. And if Mr. Palacios wants to ask questions of Mr. Alarcon is here in the hearing and he's ready to testify to his affidavit.
Okay, let me get him in. Oh, he's already on. Can you hear me, Mr. Alarcon?
Yeah, yes.
Okay, you understand English?
Yeah.
And you don't have a video?
Yeah, I'm just trying to. That's because it's that I need to approve here my computer. Hold on.
All right. All right, there you go. Now we can see Mr. All I see is a big DA there, and we don't know what that is. But anyway, Mr. Alarcon, there's going to be a few questions here being asked by the attorneys, so just listen to them carefully, okay, sir?
Sure.
Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. And Mr. Palacios, you may begin, sir.
Mr. Alarcon, please forgive me my mispronounced your last name, Alarcon. I have a hard time stuttering already, so pronouncing a new word is gonna. I'm sorry if I'm butchering your name already, but Mr. Alarcon, when did you? What were your years of service at Top Choice used cars?
I think it was
when did you get hired?
Yeah, I think it was end of 2017, if I'm correct.
Like roughly around November, December 2017?
Yeah, around that, end of 2017. It should be close to those times.
Okay.
And when did you leave?
So I got a personal matter that I don't think it's important for this. So I left around May 2018.
May what?
The beginning of May.
May what?
The beginning of May or so.
2018?
Oh, 2018. Yeah.
2018.
Yeah.
Okay.
So you hadn't been at Top Choice from 2018 to 2020?
No.
2018 to 2020. Okay. No. Okay.
So when there was an attempted service out there, you're saying you were not employed anywhere near Top Choice Auto.
Correct.
Top Choice Used Auto. When a default judgment was mailed to Top Choice Auto, you stated in your affidavit that I was contacted by someone who knew me. Who is this someone who knew me?
It's a friend. It's a friend.
I'm sorry?
It's a friend.
What's his name?
It's important for the case, the friend, the name?
Yes.
It's not even related with Top Choice. So
what's his name?
But it's not even related to Top Choice. It's just a friend.
Is it someone that works there, or an employee, or what is
it was
the owner?
It was at the same location that Top Choice was located, and that's a location. Not even close to.
Okay. So, what's the name of the person that called you?
it's important for the matter. I don't know if my lawyer needs that information.
Diego,
Sure,
go.
I need
Judge,
to
I'm
know
gonna
the,
object to-
yeah,
I'm
we
gonna-
need
I'm
to know
gonna
the
object
information.
to
If I
that.
don't get the information, I may not grant your motion, so you
No,
you
I'm
need
just,
to go
I'm
ahead.
just
and
asking. That's why my lawyer here. If it's information that I need to.
Diego, go ahead and mention the friend.
Okay.
Mention his or her name.
Yeah, Miguel
Miguel what?
De Lucio.
De Lucio? What's Miguel De Lucio's phone number?
I don't have it on hand, but if you give me some time, I can try to get it to you. Or I can just make
You
my
said-
lawyer send it to someone.
You said when he contacted you, did he contact you by phone or did he contact you by going over to
Yeah,
your
he
house?
contacted me. No, by phone.
Okay. And that was recent, just within the last 30 days?
Yeah, I don't know the exact date, but yeah, it was recent. Basically, in the moment that I got it, okay, this is the letter. I contacted the lawyers and I gave them the letter. I didn't know exactly what was it for until obviously making a little bit of research, and that's when we're at this point.
What's Miguel De Lucio's address? His home
What?
address? What's Miguel De Lucio's home address?
I don't know.
What's his business address?
I don't know what's the business address.
Where does
I
he
don't know if
work?
I don't know if he has a business.
Where does he work?
The same location,
Which location?
the 927.
The 927 West Expressway. So he works at Top Choice Auto currently.
No, there's no top choice at that location.
Okay, so he works there at whatever business is there now. He works there currently.
Correct.
And what's the name of the business now?
I think it's something with a K, KS something.
K what?
KSW,
KSW? And what do they do at KSW?
sell units, like
Sell what?
yeah, heavy equipment.
Sell heavy equipment? So they sell heavy machinery. Is that correct?
Yes,
Is KSW what used to be Top Choice Auto, used auto? Is it from the same owners?
not that I know.
It just, your testimony to the court is it just so happened that the same place where you worked in back in 2018, which was Top Choice Used Autos, is now another business, unrelated business called KSW.
Again, can you repeat that?
Is that your testimony to the court?
Can you repeat it to me again, please?
Is it your testimony to the court that the business that you used to work at Top Choice Auto there in 2018, and that the business located at the exact same address today is now called KSW?
You're asking if the same business.
If that's
now
your
is called
testimony to the
KSW,
court.
or if you're asking if it's a different business that is now called KSW.
Okay. Is it your testimony today, Mr. Alacron, that the business you worked in 2018 at 927 West Expressway 83, Westaco, Texas, was called Top Choice Auto? Is that correct?
Correct.
And is your testimony today that that same address is now called KSW?
That same address, it's a business now called KSW.
And is it your same testimony today that they are unrelated businesses?
Yes.
And it's the same as your testimony today that your friend, Miguel, correct? Works at the same address that you used to work in 2018 by happenstance.
Sorry, I think it's cutting a little bit. The last part again?
By happenstance.
By
chance.
I lost that, Miguel. If Miguel is what?
It's your testimony today to the court that it just so happens that your friend Miguel De Lucio works at KSM at the exact address you worked at in 2018. And yes or no?
Yes.
And it's your testimony today that he just happened to get the default judgment and call you.
Yeah, because he knows my name, of course.
How often do you talk to Miguel?
What?
How often do you talk to Miguel?
Regularly.
Okay. You all hang out?
No.
So regularly, how often do you talk to them? Once a week, twice a week, once
More
a
or
month?
less like once every 15 days, more or less, twice a month, or twice a month, more or less. Yeah.
You have your number saved on your phone?
Yeah, hold on. I'm not busy. Nine 956. Number now. Oh.
If it makes it easier, can you just put your phone to the screen?
Oh, sure.
Nine 408-5944.
Yep.
Okay. And you said you speak to him every 15 days. You text him or you phone call him?
Well, it's been a little bit like a month that I haven't spoken with him since he told me that, but it's just regularly. You know, some months are a little bit more than others, but it's just regularly. Yeah.
At this time, I'll pass witnesses.
All right, Mr. Garza.
I have a couple of questions for Mr. Alarcon. Mr. Alarcon, you say that you text or communicate with Mr. De Lucio every 15 days or so. Has that always been the case? Or in 2020, 2021, when service was attempted, did you communicate with him in the same timeframes within 15 days? Or was there a time where you didn't contact him?
Yeah, there's a time, you know, sometimes you speak with them for a while, and sometimes it's a little bit more time, but it's not something that I can tell you right now. This is the exact timing. It's hard to know, but sometimes it's more regular than others.
Okay. And everything that's in your affidavit is true?
Yes.
Would you say everything is true?
Mm-hmm.
Okay. I'll pass the witness.
Mr. Alarcon, your testimony is that everything in that affidavit is correct?
Yes.
Okay. How long has Mr. De Lucio been working at KSW?
Not that I know.
I'm sorry?
Not something that I know.
Was it his first day when he contacted you?
What?
Was it his first day when he contacted you?
Not that I know. Sorry.
Okay. And so he in all his time.
I don't think so. It should be for more, but no.
In all this time of being friends with them, talking to him 15 days, every 15 days, you've never known where he worked until that day?
I don't know the exact day that he started. What are you telling me right now? That's if that's the idea. I don't know the day that he started. But
okay, was it in 2022 that he started working there?
No, I don't think so. It should be before that.
It should be in 2021 that he started working there?
It should be more than 2022. Yeah.
So when you stated in your affidavit you did not have contact with the people there anymore, that's a lie, isn't it?
No, but it's saying that I don't have contact with the people at Top Choice. I don't have.
It's not saying you didn't have contact with the people at 927 West Expressway 83. Is that correct?
Well, the affidavit said I don't have any more contact with anyone at the Top Choice company.
But you did have contact with somebody at 927 West Expressway 83. Is that correct?
Yeah.
Right. So when you stated, I do not have contact with those people anymore, because your statement is, I left and did not work at that business or that location. I understand. That's why I asked the question about Top Choice. Is Top Choice KSM? Your testimony is Top Choice is not KSM. Is that correct?
That's correct. Yeah.
Your statement is Top Choice and KSM have previously or are now at 927 West Expressway 83. Is that correct?
Can you repeat that to me? If what?
Your testimony today is that Top Choice and KSM have previously either been or now at 927 Expressway 83. Is that correct?
Yeah, that's correct. Yeah.
And your testimony today is, even though you stated you do not have contact with that people anymore, you do have contact with people at 927 West Expressway 83. Is that correct?
That's correct. Yes.
And attempted service upon 927 Expressway 83 is correct, is it? Was correct at the time?
Well,
that was the business address, right?
Well, that's a business address. I don't know what's the exact address. It says Westaco, so that's not the exact address. And
well,
the only information
it also,
yeah, the only information
is
that
a
I got at
business?
the end, the only paper that I got is the one that I got at the end.
Right. So if the business, if you're saying that the 927 West Expressway 83 Westaco, Texas is not the correct address, but that's where the default judgment was mailed, then it is a correct address, isn't it?
Somehow they got it, but it's not the correct address. Yeah. I don't know if before something happened or they lost or something, but yeah, somehow they got it. Yeah.
I'll pass one, Judge.
Mr. Alarcon, what you mean by not the correct address is that the 920, because there's a 927 West Expressway 83 Westlaco, and then a 927 West Expressway 83 Donna.
Donna is the correct.
That is correct, right? And there is no the where you worked at Top Choice. What was the address there?
In Donna.
In Donna, the 927 West Expressway Donna. And when service was attempted at that location, were you there at that location working?
No.
No. Okay.
I don't know when. I don't know when they did it, but no.
Okay, you didn't receive it while you were there, correct? No. And then, so the first time you heard about the lawsuit was when Mr. Miguel de Lucio called you to let you know that there were papers there from a court for you. Is that correct?
That's right.
Okay. And as far as the business side of the Top Choice and KSW, how the entities are related, I mean, you're not privy to that. Is that correct? You don't know exactly how the businesses are set up, or who was there before you were there and afterward? You just worked at Top Choice.
That's right.
Okay, and then you no longer work there, and when you no longer work there, that's when Miguel de Lucio called you to let you know about the court papers. Is that correct?
Yeah, that's correct.
Okay, I'll pass the witness.
Mr. Alarcon, do you know who Ana Ballesteros is?
Yeah, I know her.
Who is Ana Ballesteros?
That's the first lady that I know, and she.
Objection, Judge. How is this relevant to the motion for new trial? It's whether he got notice of the.
I think it's going to make it very clear, Judge, as soon as he states it.
But
Mr. Alarcon, who is Ana Ballesteros?
Yes, someone I know.
And she in fact is the owner of KSW, isn't she?
She in fact passed away. If you want.
I'm sorry?
She in fact passed away. If you want to know.
I'm sorry?
She passed away. So if you want to know.
Right, but she was the owner of KSW. Is that correct?
Not something that I know.
All right, but you did know her.
I knew her. Yes.
Okay. And you're aware that KSW has been registered at 927 West Expressway 83, Donna, Texas, since 2017, December 13th, 2017. Is that correct?
Not something that I know.
As a matter of fact, your testimony is that you even started working at 927 West Expressway 83, Donna, Texas, right around November, December 2017. Is that correct?
Yeah, that's correct.
And if it's true and correct that KSW has been in the same location as Top Choice Used Auto and KSW at the same location, your testimony earlier was that they were unrelated, when in fact they have been related since 2017. Is that correct?
Not something that I know.
And even at that, 2017 is when you were there. Is that correct?
Yeah, that's correct. But it's something that has to do with something.
And even at that, your testimony is that even though you were paid under Top Choice Used Auto,
I just,
you knew
yeah.
Ana Ballesteros from this.
I don't know if you have a time to make just one quick question.
As a matter of fact, your whole testimony here is based upon the fact that KSW is one entity, Top Choice is another entity, and there is no connection between that. Is that correct?
My testimony says that I wasn't there at the time of the serving or the
I
time
understand
of
that,
the
sir.
papers they gave it, and that I don't have nothing to do with the business anymore.
Why would he have to know the relationship?
Judge sidebar, Judge.
Okay.
Mr. Garza can object all he wants, but he does not need to testify for his client.
Okay, Mr. Palacios, I think what Mr. Alarcon is saying is he used to work at this location.
Judge, I guess if
on
I guess
27.
if maybe Mr. Garza could make closing arguments, I think that would probably help right now.
Okay, from December 2017 to May 2018, right?
That's correct.
That was the period that he worked there, from December 2017 to May 2018. And when was service attempted on him? What dates?
It was, the motion for substitute service was filed August 6, 2020. Suit was filed April 13th, 2020.
Service was attempted in 2020, Judge. And all this, our contention, Judge, is all this time that where attempted service was, and Mr. Alarcon had contact with the people, because his testimony, he had zero contact with anybody from 927 West Expressway 83. When the truth of the matter is, he had contact with them. He was friends with them. He knew the owners. He worked there. The business are the same businesses, whether it's just changing names or using the same names. Judge, and if I may share my screen.
All right, let me try to do that here. Go ahead.
Mr. Alarcon, can you see my screen?
Mm-hmm.
Is that a yes?
Yeah, that's it.
That's an assumed name certificate. You see that?
Yeah.
Registered with the county, Hidalgo, down here. The name that I told you right here, Ana Ballesteros. Do you see that name?
Yeah.
And you said that's your friend or your acquaintance who's now passed away.
I never said it's a friend, but I knew for years.
Right. And as a matter of fact, that address, can you read that address right? That's that I'm pointing at right there.
It's 927 West Expressway 83, Donna, Texas.
And that's the address. That's the company that's there is what company? DSW.
KSW, huh? Rail.
I mean KSW. That's the address you stated that your friend works at, Miguel De Lucio. Is that correct?
It shows there, yeah.
Owned by your friend Ana Ballesteros. Is that correct?
No, it's a friend. I said I knew her, but yes.
And the address that business began was December 13th, 2017. Is that correct?
I see there. Yeah, I suppose.
That's what it purports to say, right? And that's around the same time you started working at 927 West Expressway 83, Donna, Texas. Is that correct?
Well, it's not that date, but not that I'm close to that.
Well, your testimony is on or about December of 2017, you started working at 927 West Expressway 83. Is that correct?
The only that it states on my paper that I sent is that I don't have anything to do with.
I understand, sir.
So
I'm going to object to non-responsive. Your testimony earlier was that that you worked at 927 West Expressway 83. Is that correct?
Yeah.
Okay. So once you left in 2020 or 2018, is that correct? You had your testimony. You had zero contact with anybody from that address, from 927 West Expressway 83.
Yes, to having contact with them was contact as them as in business, if you want to say it that way.
Okay. And your testimony is that they never contacted you. Hey, somebody tried serving you on multiple occasions out here? but they did contact you that, hey, there's a default judgment against you here.
They didn't call me.
Objection, Judge, that's mischaracterizing what he said. He said they contacted him to let him know that there was papers from the court. They didn't tell him there's a default judgment against you. Hey, there's
Okay.
something from the court for you. That's what he had said.
And Judge, and that's why it's so important that before this court rules, they'll give us a chance to subpoena Mr. Lucio and have him testify as to what his statements were, because Mr. Alarcon's statements to test the veracity or the conscious indifference, all are going to turn on Mr. Miguel de Lucio's testimony as to whether it was and how much contact and what exactly Mr. Alarcon knew or didn't know, and whether he just evaded service, thinking this case was going to go away.
What Mr. Alarcon knew, Judge, can be figured out right now. Mr. Alarcon is right here. Even if the service was attempted at 9:27, and even if Miguel de Lucio or everybody at that location knew, that doesn't mean that Mr. Alarcon knew. Mr. Alarcon knew when they let him know that there was court papers there was a default. He saw it. He spoke to his attorneys, and then he filed the motion. I mean, even if Mr. Palacios proves, or even if it were to be true that service was attempted at 9:27, that doesn't mean that Mr. Alarcon knew. That's the important fact, Judge, that whether he knew or not. And
the fact does not turn on whether Mr. Alarcon knew whether he was served. The fact depends on whether Mr. Alarcon evaded service, number one, or even number two, that a case was even ongoing. It could happen, Judge, because there can be more testimony from Mr. De Lucio and more evidence to show that he did have in fact have contact with this office, with that business, that he did in fact have in contact with everything that was going on, and whether he was knew of the service or the publication. All this tenders on whether Mr. Alarcon did in fact have contact with anybody from that business around 2020. His statements are very simple. I left work and I had no contact with people there anymore, which is false. He did have contact with people from 927 West Expressway, 83 Donna, Texas. His testimony that KSM and Top Choice Used Auto have nothing to do with each other are false. We have shown, in fact, that they are the exact same address at the exact same time, at the exact same place where he stated in his testimony that he worked from that time to that time. So what I'm going to ask the court to do is, if they give us time, or the court's inclined to grant the motion for new trial, if the court orders to mediation as soon as possible, as not to cause any more waste.
Judge, the relation between the businesses is not relevant to the motion for new trial. And Mr. Alarcon did not say that he always spoke to him every 15 days since 2017 to date. He worked there for a time, then he was gone, and then they told him about the papers, and they're friends, and they speak now. That doesn't mean that they've spoken every 15 days forever. I mean, okay. Mr. Alarcon worked there for about a year or so, then he was gone. And whether they communicate now doesn't mean that they communicated all the time. And he was served by publication. I mean, he never got the papers.
Gentlemen, what kind of a case is this? This is
it's a breach of contract and conversion. Plaintiffs.
This is a case, Judge, where my client dropped off a vehicle, an 18-wheeler, a tractor trailer, to Peterbilt to the address and trusted to Mr. Alarcon, who sold them and was supposed to make repairs. Mr. Alarcon then effectuated the sale of the 1994 Peterbilt tractor. Since then, my client's been out of his Peterbilt tractor, and we've been trying to recover. Now, whether he's recovering from, we're trying to find out who conducted the sale, whether it's Mr. Alarcon, whether it's whether it's Top Choice Auto or any of that. But what the problem with this whole case is that when it's all said and done, it's my client that is still out a 1994 Peterbilt tractor, and Mr. Alarcon is the one that effectuated the transactions.
As an employee.
We don't know that, Judge.
They're suing a former employee, Judge, and they have a default judgment for over $160,000 based on service by publication. And He's now
That-
here. He's answering.
that's-
Open the trial and litigate the case. Work the case. I mean, why would a default judgment for over $150,000 stand against a former employee who's now
Judge,
appearing to tell you,
that's-
hey, I didn't know about it.
and-
I'm here. Let's open it up.
Okay.
And that's the problem with this case, Judge. We don't know what his function was. We don't know since 2020, Mr. Alcon hasn't made himself available to the case, and we have used every legal option available to us to send him notice. Now, whether he's stating now, as he's stating now, that there was no way, absolutely no way he could have had any contact during all this time, or even during the default judgment, any of the notices that were sent to the court to the business regarding things leading up to default judgment hearing, none of that.
But Mr. Alarcon was an employee of the business?
He worked there, Judge, and then for a time, and then he no longer worked there, and that's when suit was filed, when service was attempted. And by the way, Judge, I would point out that service by personal delivery was attempted only once at that address, and then they immediately requested service by publication. And he like Mr. Alarcon has said, he didn't know about it till after the default, when somebody told him, apparently
Okay.
Mr. Miguel de Lucio, hey, there's court papers here, and now he's showing up.
And Judge, just for the court's for the court's notice information, the service was attempted by Audrey from the district clerk's office and her service process business.
Okay.
So it was not just once; it was multiple times at that location. That was
That's
just
not what the motion
last.
says, Judge. That's not what
Okay.
the motion they filed says.
Well, let me review the whole thing again here, even service and whatnot, and whatever is on file, all pleadings, and let me see what I can do here. But the only one that was sued here was Mr. Alarcon, right?
That's correct, Judge, because that's who sold the vehicle. That's who took possession of the vehicle, and that's who notified our client that the vehicle was that the 1994 Peterbilt tractor was then subsequently sold. We don't have any information as to who sold it. It could be that Mr. Alarcon sold it without Top Choice Used Auto's consent. We don't know that.
Judge,
Okay.
and
Which is why we have the conversion to the claim.
And the point of this hearing is just whether the default judgment should stand against Mr. Alarcon, and he was served by publication. That's just the whole deal right now.
Okay. All right. Court will go ahead and take this matter into advisement. We'll go ahead and review the all pleadings, and then also look at the services that was done here, and we'll give a ruling hopefully next week.
Thank you, Judge.
Okay.
Thank you,
All
Judge.
right.